We'll hear argument first this morning in Case 10-277, Walmart Stores versus Dukes. Mr. Boutros.
Mr. Chief Justice, and may it please the Court, the mandatory nationwide class in this case was improperly certified for two fundamental reasons. First, plaintiffs failed to satisfy Rule 23A's cohesion requirements as reflected in the commonality, typicality, and adequacy requirements of the rule. Second, plaintiffs' highly individualized claims for monetary relief failed to satisfy Rule 23B2's requirements for certification of a mandatory non-opt-out class. Regarding Rule 23A, because the plaintiffs' claims in this case hinge on the delegation of discretion to individual managers throughout the country, they cannot meet the cohesion requirements that are reflected in Rule 23A. The delegation of discretion in some ways is the opposite of cohesive claims that are common to everyone in the class. The common policies that the plaintiffs point to are either neutral and not argued to be discriminatory, or they are affirmatively non-discriminatory. The company has a very strong policy against discrimination and in favor of diversity.
I suppose if corporate headquarters had learned that the subjective decision-making or the delegation of decision-making to the field was resulting in several discriminatory practices or a pattern of discrimination. In other words, the decentralized process was leading to discrimination. Then I suppose the company that could be attributed to the policy adopted at headquarters?
No, Your Honor. I think that in this situation, if there was a pattern, for example, at a particular store where the decision-making—
No, I'm talking about, so they've got thousands of stores, and, every week they get a report from another store saying, there's an allegation of gender discrimination. At some point, can't they conclude that it is their policy of decentralizing decision-making that is causing or permitting that discrimination to take place?
I think that would be an inquiry, Your Honor. I don't think it would rise to a pattern or practice or a common policy that affects everyone in the same way. Certainly, companies do look at the situation throughout the company and seek to root out discrimination. But it would take more than some reports, especially in a company that has so many stores and so many units. And here, the plaintiffs' claims simply aren't typical. If the three named plaintiffs stand before the court, they are supposed to represent 500,000 or a million or more people and stand in judgment. That's the words the court used in Hansberry versus Lee, to represent all those other people. And the claim is that the individual decision makers in those other cases exercised their discretion in a way that was biased, and there's no proof of that.
The Chief Justice's question reminds me somewhat of our rule in Monell under 1983. A city's not liable for a constitutional violation unless it has a policy. Would you think that we could use that as an analog to determine whether or not there is a common question here?
Yes, Your Honor. I think the analog is that if a company had a policy, a general policy of discrimination, as opposed to here where it's a general policy against discrimination, and it was, in the words of the court in Feeney, saw patterns throughout the company, and because of sex, because of gender, continued to allow the patterns to exist, that would raise a different question.
Suppose, following the Monell analog, there's a showing of deliberate indifference to the violation. Would that be a policy?
Your Honor, I think deliberate indifference raises a different question. Under a disparate treatment claim, again, in Feeney, the test would be, was the company allowing the discrimination to occur because of gender, because it wanted there to be discrimination. There's no evidence of that here.
Isn't there any responsibility if the numbers are what has been left out so far? The company gets reports month after month showing that women are disproportionately passed over for promotion. And there is a pay gap between men and women doing the same job. It happens not once, but twice. Isn't there some responsibility on the company to say, is gender discrimination at work? And if it is, isn't there an obligation to stop it?
Your Honor, yes, there is an obligation to ensure for a company to do its best to ensure there are not wage gaps and discrimination. But here, for example, if one looks at the aggregated statistics that the plaintiffs have pointed to, it points to a completely different issue. It does not show that there were gender gaps at the stores and among comparable people. That's really the fundamental flaw in their case. Their argument is that individual decision makers throughout the country were making stereotyped decisions and that had a common effect. But they just added everything together. They haven't shown a pattern across the map. They've added all the data together and pointed to disparities, some which mirror some of the statistics that —
Counsel, I thought their expert didn't aggregate them together. He did it regionally, not store by store, as your expert did, number one. And number two, that he performed, as accepted by the district court and affirmed by the circuit court, any number of controlled variable comparisons, including job history, job ratings, and other things, and found that the disparity could not be explained on any of the normal variables that one would expect, and that the disparity was significantly much higher than the 10 competitors of Walmart and what they were paying their labor force. So what is speculative about that, number one? And two, why is that kind of statistical analysis inadequate to show that a policy of some sort exists?
Justice Sotomayor, first, plaintiff's expert did a national regression and then simply estimated the regional results. He did not do a regional regression. But even if he had, these statistics go more to the merits. We think we have strong arguments on the merits responding to those statistical arguments.
Well, that begs the legal question, which is, you're right. Ultimately, you may win and prove to a fact finder that this analysis is fatally flawed. But what the district court concluded was that on the basis of your expert, whom he discounted because your expert was basing analysis on premises that the court found not acceptable, that there was enough here after a rigorous analysis. What's the standard that the court should use in upsetting that factual conclusion?
Your Honor, the district judge did not discount Walmart's expert. The district court found that it wasn't the stage at which to make a determination between the two. The standard that we think would govern would be the standard that the Second Circuit adopted in the IPO case, which says there needs to be a choice. When you're talking about discretionary decision around the country by different decision makers, there has to be some demonstration that there's a common effect throughout the system. Our experts' report and testimony showed that at 90% of the stores there was no pay disparity, and that's the kind of — and even putting that aside, the plaintiffs needed to come forward with something that showed that there was this miraculous recurrence at every decision across every store of stereotyping, and the evidence simply doesn't show that. The other problem on the cohesion analysis is again, the typicality inquiry. Each of the plaintiffs have very different stories. One of them was promoted into a managerial position. One was terminated for disciplinary violations. One was promoted and then had a disciplinary problem and then was demoted. In each of these cases, if this were an individual case, they would have to show that they were treated differently than people who were situated just like them, with the same supervisor, the same department, the same situation.
And what do you think is the difference between the standard that the district court was required to apply at the certification stage on the question whether there was a company-wide policy and the standard that would be applied on the merits?
At the certification stage, Justice Alito, the plaintiffs did not have to prove that there was an actual policy of discrimination and that was the company's policy. But they at least needed to point to a policy that was common and that linked all these disparate individuals, different locations, and different people together. And their argument is that the common policy is giving tens of thousands of individuals discretion to do whatever they want. That is not commonality. It's the
Well, I don't think that's quite fair, Mr. Boutros. I think that their argument was that the common policy was one of complete subjectivity, was one of using factors that allowed gender discrimination to come into all employment decisions. And in Watson, we suggested that was a policy of using subjective factors only when making employment decisions. That's exactly the policy that was alleged here.
Justice Kagan, they do not argue that it was an entirely subjective process. As the Court suggested in Falcone, entirely subjective would be a different issue. They argue that it was excessive subjectivity and that there were general overarching company standards that exerted control.